this is to you, ma'am. In the light of this pandemic, we have a question as the insolvency threshold has been increased 100-fold to rupees 1 crore. So operational creditors can be disadvantaged from it as the quantum of their debt is generally low. Therefore, it is being argued by the industry experts that there should be a differential threshold for operational creditors. So what are your views on the same?
Ritika, I am very wary of having different threshold for different categories of creditors, because as much as we believe that commercial laws do not follow one size fit all approach, but having different threshold creates a lot of scope for controversy, litigation, and confusion in law. And it's the need for commercial law is that it must be certain, it must be predictable, and then only market acceptability for such law is higher. So honestly, I do not think personally that there should be a separate threshold. But you've raised some very valid points that over the time, insolvency law, IBC started with a very good objective of protecting the rights of OCs, operational creditors, which in many discussions initially I had expressed my reservation of giving equivalent treatment to OCs as financial creditors. But over the time, I have also learned what the importance of it. I may not agree with that, but I still have sort of understood the legislative intent better. Coming to the point that different thresholds, I'm not sure it really suits the purpose of the law. Firstly, increasing the threshold from 1 lakh to 1 crore, that's a humongous jump. I'm told that the intention of legislation was to stop frivolous, litigation, as sort of arm twisting that was happening, using IBC as a tool, which I think Pulkit will have more practical experience of that. Some people also say that this threshold was increased so that a lot of businesses which are not doing well are not forced into, insolvency because of the minor defaults that may have occurred due to, the COVID-19 impact. So honestly, I think Pulkit, you could share more details as to how does business, sense this change. What are your views on this?
No, you're absolutely. I think you're bang on the money. It's difficult enough to adjudicate an insolvency petition now, which is counterintuitive. I mean, you at university you would read the law and you see, all right, you've got to adjudicate the thing within 15 days, but that just isn't, practical for a court to do, because you've got to. You may have the best of intentions, but you've got to, sort of proceed in accordance with natural justice, which means you have to give an opportunity for a hearing to the other side. And if you issue notice to the other side, right, that in itself is going to eat up 15 days. The other side is going to turn up and then say, let me file a reply on affidavit. That's going to take up another 15 days. The petitioner again will say, all right, now let me rejoin, and that will take up another 15 days, and so on and so forth. And sometimes judges fall ill and they're just not able to hear the matter. So it goes on, and especially when you consider interlocutory applications left, right, and center that any corporate debtor would certainly file to delay matters. You've got to issue notice on those, and you've got to allow the other side to reply and rejoin and argue and so on and so forth. And so it's just not possible to adjudicate a matter within 15 days. So that being the case, right, that being a given, your courts are cluttered. Now, when your courts are cluttered, you've got to realize that, increasing the complexity in adjudication is not going to help the situation. Unfortunately, we are not a country where litigation is the last resort. We are a country where litigation is the first resort, if not the first, maybe the second resort, because it's so cheap. Getting a lawyer to file a petition and argue it out is not expensive in a country like India. And unfortunately, that means that judges just are not able to give as much time as you would want should be given in order to achieve justice. Now, you've got to realize that, again, in a country like India, you don't expect 100% justice to come on every petition. I think, and Neeti will correct me if I'm wrong, but I get the feeling, I've got the feeling over the years that, look, we're trying to do substantive justice in that at least 60% litigants who come to a court get justice, and we'll be happy with that. I think if we're able to achieve that, we're happy with that. So now, that being the case, you see, these are pragmatic issues. In a perfect world, yes, have a differential basis. It would be ideal, wouldn't it? But it's just not practical. Now, England has come up with something during this time. They're saying that if there's a default that relates, exclusively, to the COVID period, in that the default has happened because of COVID, because of business interruption, due to COVID, well, the judges will have the discretion to dismiss such a petition. But is it practical in India? I would say no. So you've got to pick the lesser evil and say, all right, everything that's happened during this time, let's say at least 60% of that is going to be due to COVID. And so let's put a bar on the whole thing. Let's just put a lid on it. Let's do substantive justice, not absolute justice. And when you think about these issues, right, you realize that this is actually the lesser evil than going for an idealistic sort of a provision which the courts have a very difficult time sort of dealing with.
Just to add that bit, Ritika, different default threshold for different creditors, different types of creditors is not most desirable, regime. But what could be the option probably is that, they still have options under civil laws. They can file a civil suit, for the payments. I think the problem they would face is that due to due to the force majeure legislation that India has passed recently, that this event will be deemed as force majeure. There could be a lot of debate and litigations around that. So to show a causa on like a connecting factor that it is impact of COVID, that would be a problem outside IBC. Within IBC, I think the ordinance makes it very clear. There's a blanket suspension, so that's at least more predictable. For good or for bad, I mean, we don't know, but yeah. So I think that is also a problem. But operational creditors may have some sort of relief outside IBC. Do you think, Pulkit, that could be a way out for them? OCs having some.
Well, the OCs have a relief, have a remedy available to them outside the IBC. You see, I mean, I think it's almost trite now to say that you shouldn't be, trying to shortcut the legal process, just by putting a petition in IBC, because that essentially you're using as an arm twisting mechanism or as a, threat to take away the company from the promoter's hands. So of course, you see, to say that you can't put a company into insolvency if the default is less than 1 crore is not necessarily, the wrong thing, because for the large majority of companies, 1 crore would perhaps be the right level. For a smaller minority of companies, may be the wrong level. But again, when you think about things like doing substantive justice in a country like India, this is the lesser evil in my view. And in fact, I'll go a little further. If you did come up with a differential sort of a mechanism, what would it be? Would it be a percentage basis of your debt, like 10% of your debt of a company's debt would then be qualifying? Well, if you did do something like that, how would the courts go about, sort of determining what that is for every company? Especially when you think about the 15-day timeline. Granted that it's not to be observed, but you've got to do, what you can to do things as fast as possible. Your debt level as a company will change every day, isn't it? It's not going to remain the same. So you've got to complicate it a bit more and say, all right, now it's going to be your average debt over the last 6 months or 1 year or 2 years. If it's the last 6 months, well, that's not going to work in this situation because, 3 months, people probably haven't paid. So, complication will lead to further complication and would lead to then, denial of substantive justice. In fact, there's another issue on the other side. If you sort of think about it, why increase it to 1 crore even? And to address that, I think we've got to get into a deeper psychological issue that we have in India as Indians, where we think of liquidation and bankruptcy as bad things. They're not bad things. People have got to realize, liquidation is not necessarily a bad thing for a company. But that's a separate conversation altogether. If I were to just quickly sum it up in one sentence, which I think might be useful for this conversation, I'd say that liquidation is still restructuring. It's not different from restructuring. It's just an extreme form of restructuring. Because at the end of the day, even if you liquidate a company, you redistribute its assets. Banks get something back, and that's given to somebody. That money is then given to somebody else. On a wider scale, it is still restructuring, and I think the perception has to change. So to say that liquidation is not a bad thing, but just an extreme case of restructuring, and so inherently a good thing.
Though I have a follow-up question, sir. So what is the use of suspending the IBC as the next best alternative, SURFACE, just strips away the assets of the corporate debtor and does not help the objective of keeping the company as a going concern and isn't in line with the macro level objective behind the suspension in the first place?
Yeah, very good question. It's a very good question. You allow people to enforce their security, but you don't allow the company a moratorium. You're absolutely right there. There's a serious lacuna here if that is your ultimate goal. But as I said, just in my statement a minute ago, liquidation is not a bad thing. If the ideal scenario is that that you recover your debts, you sell the you recover your security, recover your debts, redistribute it to somebody else who needs it and can keep going. That's not necessarily a bad result. That's a good result, if you ask me.
Thank you for the answer, sir. So I have the next question that in this time of severe distress, demands are being raised for pre-packed insolvency. So can you please let us know what is the pre-packaged insolvency?
Neeti, do you want to take a stab at that?
Sorry?
I think I won't do justice to the question if I take, but just for the audience knowledge, Pulkit has worked as an IP in English and he has hands-on experience of pre-pack. So maybe you start and then maybe I can chip in as to how the court's role should evolve around pre-pack.
Yeah, okay. So when somebody says pre-pack to me, you see, pre-pack is a very specific thing. It's not a general term such as corporate rescue or restructuring. It's a very specific mechanism which is special to the UK, to England. And I think the word is being used loosely nowadays for a certain reason. And the reason is that it represents a particular type of a situation. In India, we made a conscious decision to move away from debtor in possession style corporate rescue mechanisms when we did away with the Sikh Industrial Companies Act. And we adopted a creditor in possession style corporate rescue mechanism when we picked up the IBC. Now, pre-pack essentially is actually a debtor in possession style corporate rescue mechanism, which masquerades as a creditor in possession style corporate rescue mechanism for the reason that a pre-pack is a voluntary process, a non-statutory voluntary process that is run before a statutory process of administration is commenced in respect of a certain company in the UK. Now, what they try to do is they try to follow the statutory scheme as much as possible, but in a non-statutory setting. They conduct a valuation, a viability study, draft up a restructuring package, all in a voluntary manner, all leading from voluntary negotiations in a non-statutory setting, while the promoters remain in control, management and control of the company. And once the whole thing is done, once the package has been stitched together, and this is actually, as a matter of fact, this is practically what is done. You file a paper application. So in England, again, you've got to realize that there's a big difference between how petitions for insolvency or corporate rescue are adjudicated as opposed to in India. In England, an application for administration is what's called a paper application, which means that you don't actually have a hearing. The judge receives the documents, reads through them in chambers, and passes an order in chambers without hearing anybody. Very different from what happens in India. So what they do then is, once the whole package is stitched together, they file a paper application in the morning. In the afternoon, administration proceedings are initiated because it happens all on the same day. You file a paper application in the morning, you get an order by the afternoon or the evening, right? Now, once they get the order, as soon as they get the order, and the clerks go and sort of pick it up and come back and tell the solicitor, all right, now we've got the order. The solicitor calls up the IP, says we've got the order. They call up the banks and say we've got the order. Excellent. Let's all have a meeting. And of course, everybody remains available. They immediately get together in a room. They sign the packaged documents. So the whole transaction is executed there and then, which they've worked through over the last month or two, right? There and then execute the transaction. And either in the evening or the following day, the IP will file an application to say, put the company into liquidation. Company itself goes into liquidation immediately, or almost immediately. And this is practically how it happens. It happens within a period of a day or two, not more than that. Right? Within 2 days, you've restructured the company's business and operations and assets and liabilities and so on, right? Within the statutory framework. You may have taken a month or two to stitch it up before, and you've put the company into liquidation, to winding up. That's your classic pre-pack in the UK. Now, what does it mean when you use the term loosely? I think, I'm sorry, I'm not answering your question immediately, but I'll get to it in a minute. I thought that it would be useful to sort of take this time to explain what it actually means, and then what it implies when you use the term loosely. When you use the term loosely, I think what it means is a corporate rescue mechanism with a debtor in possession as its base, essentially. And what would it mean for India? Now you would ask the question, what would it mean for India? So before you sort of say, all right, it makes sense, you've got to think about how would you do a pre-pack in India and what do you need to do it. Now, essentially, if you were to take a leaf from the English law book, you would realize that a pre-pack is actually not there in any of their legislations. None of their statutes deal with the pre-pack. Nobody explains, in a statutory book, in a piece of legislation, parliamentary legislation, that this is what a pre-pack is. It's not defined. It is governed quite simply by common law. And why by common law? Because some smart IP at some point in time thought to himself or herself that, look, here's how I'm going to do it. I'm going to do the administration for you, but here's how I'm going to do it, right? Just did it. Nobody mandated that IP to do it in that way. They discussed it and they just did it. right? And then, as you would imagine, everybody challenged it and said, hold on a minute, what have you gone and done? Nobody said you could do it like this. The courts then examined the process over many years and turned around to say that actually it is a lesser evil. When you talk about insolvency, you've always got to be thinking about what's the lesser evil, because you're never going to do absolute justice to everybody, right? Everybody is not going to recover everything that they're owed. So you've got to do whatever is the lesser evil. So the court said, yes, actually, this is the lesser evil, because if you do a full-fledged administration and run the whole process through the statutory framework, most of the businesses are lost. And they're lost because justifiably, IPs are not equipped to run businesses. They are chartered accountants, lawyers, and so on. They're advisors, they are consultants, but they're certainly not businessmen or women. And if you told an IP, look, you've got to go sit down and run that plastics manufacturing facility, that IP will be like, well, hold on a minute, what do you mean run it? I don't know heads or tails about what machines are there. And if you put him or her, behind the CEO's desk in a pharmaceuticals company, well, that's it, you had it. You won't be able to trust your paracetamols. And for that reason, they justifiably said that, yes, this is the lesser evil, but you've got to have checks and balances. Now, those checks and balances are prescribed and enforced by the by R3, which is essentially by R3, by the institute companies, chartered accountants in England and Wales, and so on and so forth. So all the Insolvency Practitioners Association, the IPA. So these are the regulatory bodies that enforce these practice guidelines. They're not regulations. They're not rules. They're not prescribed by the state. They're not, they're, on the other hand, they're prescribed by the associations that govern insolvency professionals. And so they are practice guidelines, which means just that they're not binding in nature as such, but people frown upon it if you don't follow it. That's how they do it. Now, coming to India, coming back to India, sorry, I segued away from, instead of talking about a leaf, I think I talked about a few pages or maybe a chapter. But coming right back to what would it mean for a country like India? How would you do it? If you took that leaf or that chapter, whatever you want to call it, it would then mean that you don't need legislation. It would then mean that you've got to figure out a way to do what is statutorily required in a CIRP outside of the statutory setting, i.e. before commencement of CIRP, right? And then quickly put things through, right? Line up all your chickens and then put them through as soon as you get a commencement order. Now that means that everything has to be voluntary, which in turn means, now how would you do it rather? Now, how would you do it? If you put me on the spot and said, look, Pulkit, how do you think you would do it if somebody asked you to do it? Using whatever you've got, using the tools that you've already got, nothing new is going to be given to you. I would say I'm very happy doing it because actually I think the tools are already available. Everything that one needs is actually available. We don't need new legislation. That's, of course, my personal view. Nobody else is. I'm not taking it from somebody. And I'm not saying anybody else has endorsed it. This is just my personal view. Now, I would suggest that Section 10 is your perfect setting in order to do it, a Section 10 of IBC. I would also say that your RBI guidelines of June also give you a very good tool to do something like this, to put something like this through. And if you did the two things together, right? You called up your banks and said, look, let's do the 30-day moratorium under the June circular. And within the 30-day circular moratorium, you said to your banks that, look, let's work out a deal, right? And what we'll do is we'll be very smart about it. We're gonna put it through the IBC, as a matter of fact. So you work out your deal, right? Your documents are there in order. Your resolution plan, essentially what you would have otherwise worked through once your CIRP began. You worked it through before, right? You've had your lenders meetings, right? Within that extended, 30 plus 180-day moratorium. Sorry, I'm assuming that we're all aware of the RBI circular and what it says. Just in case we're not aware, just let me know in a message, and I'll go through it very, very quickly in a couple of sentences. Within the 30 plus 180-day moratorium, cumulative moratorium, you would work out your resolution plan and then put in a Section 10 application before the NCLT. Because your lenders have already agreed what a resolution plan is going to look like, or rather what it would be exactly, right? As soon as you get into the process, nothing stops you from quickly constituting the committee, right? Presenting the resolution plan once again, doing essentially what the statute requires you to do very quickly. Approve the plan and put in an application under Section 31 to the NCLT saying, please approve my plan. And because you are confident that your lenders are not going to be renegotiating because they've voluntarily already accepted the plan before you went into the statutory process, you know you're going to come out of it. That you're going to come out of it alive, and what you're going to come out of it with. So that's going to give all the stakeholders a lot of confidence while going into the process. Now, I very happily said, very happily preached to you, do everything that you need to do within the statutory framework, outside of the statutory framework. I can imagine that you'll be like, well, now make it good, right? Can it actually even be done? Well, the answer, I think, is yes, because broadly, there are only two things that need to be done, broadly. And those two things are assessing the viability of the company and conducting a valuation. Now, yes, so assessing the viability and conducting evaluation. And I don't want to carry on with this right now because I know you've got another question that deals with just this. And so perhaps when we get to that, I'll carry on with this story. But essentially, this leads us quite nicely into that other question. But as I said, we'll come to it. I hope that helped.
Just little, I would like to add to what Pulkit said. That the pre-pack, as he rightly started and made, that is a caveat that he gave, that it has been loosely used in Indian context, and I think we still need to have a lot of clarity. And Pulkit, because he had his experience in England, he has done pre-packs himself, so he knows how it translates into a solid resolution plan. And Pulkit, you'd agree with me that this is done without even much interference of courts, and which basically is premised because in England, there's a belief in business. People trust business and they don't trust courts at the first instance. And apparently even courts trust business. So, the whole legal system is not premised on disbelief, in a sense that, like look at IBC in India, the whole debate whether 29A should also be translated and to be applied to pre-packs. Should you prevent promoters from all this debates going on? Why? Because there's a lot of distrust in business that we have in India. So I personally feel that pre-packs will only see the light of the day in India, provided that we believe in business and we believe in the corporate debtor who may be facing difficulty, but he should be able to sort of make the right decision how to get himself out of this stress. I'm not sure if you have a question on your list, but look at what has happened today by suspension. Even those businesses are not doing well, the law is forcing them to continue just because there's a blanket ban on, fresh insolvency. Now look, if you understand the jurisprudence behind it, why? Because the law says no, if your company's not done well because of whatever reasons, there's a disbelief in people who are running the business. So you want to get somebody from outside to take charge of that or to make the decision whether they should continue or not continue. Now, why I'm saying this is because it's, Pulkit rightly said that there's so many other mechanisms that you have in Companies Act. Like, I always make this mention scheme. Scheme is such a flexible instrument, so widely used in various jurisdictions, but in India, we still is not very, we're not used very popularly. We're still scared of using the scheme. And I had written a paper long back, in International Economic Journal, where I argue that why it's not popular in India, because you're still debating on the power that courts have. Courts, the kind of objection they can put on scheme is immense. Unlike Australian courts, where they say that we're not rubber stamp, we look at the equity, but then a scheme has to go if it has really ticked all the boxes and if it has needed equitable representation of different class of creditors, the meetings have happened, and the interests of stakeholders are protected. We don't get into the merits of the scheme, right? Because in the end of the day, judges are not business people. They are judges who have to test proposals, be it a scheme or be a resolution plan, on the merit of law and not merit of business, right? That is somehow I feel that's missing in India. So to really ensure that PREPAC sees light of the day, I think a lot of behavioral changes needs to happen at all fronts, including the courts, the lawyers, the IPs, and all those people, the corporate debtors, the creditors, all of us who are at the helm of it. Yeah, that's all my limited submission that I wanted to make on PREPACs.
Thank you, Madam Sir. I just have a follow-up question. Since you were involved in the famous Dharani Sugar case, so how is this PREPAC insolvency different from the Prudential Framework for Resolution of Stressed Assets, which is exclusively available to the RBI regulated entities?
Yes. I'm assuming you directed it to me.
Yes.
But it has to go to you because I don't.
Yes.
My experience in the courts is almost nil.
Yes. There's of course a big difference between the two. The fundamental features of the two would be very different. As I said, as I said, I think in my Indian scenario of a PREPAC, right, what I explained a minute ago, the RBI scheme would be a good tool to use to lead you into a PREPAC corporate rescue. You see, the corporate rescue would still have to be under the aegis of the IBC, right? But you would use the RBI circular, or rather, I would use the RBI circular as a nice way of getting a pre-CIRP moratorium. Because, of course, you see, you've got to understand, in order to negotiate a deal which is voluntarily negotiated and accepted by my lenders, I would need a moratorium. I can't do it if I'm under a threat of litigation, recovery proceedings. And my lenders also wouldn't do it because they would use that threat of recovery proceedings against me to get a better deal than maybe reasonable, maybe an unreasonable deal. So a moratorium is very important, and you can't do it without a moratorium. That's my view of things. In a place like India, rather, you can't do it without a moratorium, where litigating is very easy and cheap, right? In another place, you probably could, but I just don't think that we can do it in India without a moratorium. And so for that reason, you need to invoke the RBI circular so that your lenders can all be brought onto a table and forced to negotiate with you, right? Give you at least 30 days to make your case that my company is viable and it should be restructured. And if the viability test, you pass the viability test, then you get into sort of conducting evaluation, getting your your credit ratings and so on, and figuring out what you're going to change. And you get 180 days to do that, right? Now considering that, now assuming that you use the RBI circular in this way in order to, as a precursor to a pre-pack, or rather allowing you to do the pre-pack, and sort of comparing this with a cut and dry RBI June circular restructuring, the difference would be that a pre-pack covers not only your financial creditors, i.e. the scheduled banks, but also includes your other financial creditors who are non-scheduled banks, and your operational creditors, and any other creditors for that matter. A pre-pack would be an all-encompassing scheme for all of your creditors and your shareholders and any other stakeholders there may be. A cut and dry RBI June circular type restructuring would only cover your scheduled banks. And so inherently, since there is no statutory mechanism to force your non-scheduled bank lenders and operational creditors and so on to negotiate a deal with you, a restructuring scheme with you, a pre-pack inherently is voluntary. Whereas a cut and dry RBI June circular restructuring is going to be mandatory, because it's mandatory on the banks to give you 30 days to negotiate with you if your company is viable. A pre-pack would, the second point of difference would be that the pre-pack would follow the statutory mechanism that's prescribed under the IBC, which means that you mandatorily need to conduct evaluation. You mandatorily would need to conduct a viability study, and both of them would be market-based, i.e. you would have to advertise the business to other market participants, which would then help you discover the correct price, whereas a cut and dry RBI June circular restructuring, the viability study and the valuation would not be a market-based analysis. Rather, it would be only academic, i.e. you would get your consultants who would conduct an analysis and give you a report, and that's an academic piece of work. You haven't advertised the business to the market, right? You haven't auctioned it. So you don't know. So you won't have a market-based sort of study or an analysis. That would only be academic, and this is a big difference between the two. Sorry, yes, one more very important point. I think this is not particularly profound. This is quite simply what comes from the circular. The circular prescribes that the lenders can sort of use any of the erstwhile mechanisms that were available, such as CDR, SDR, outside SDR, S4A, and so on, or they can devise a new mechanism to restructure. So there are no guidelines as such. So it's really open to the lenders what they want to do with the company, how they want to restructure it, whether they want to do operational or financial restructure. It's completely left open to them. And the IBC allows you to do something very similar as well. But of course, it also covers other stakeholders. And I think finally, a very important difference would be your RBI circular cut and dry restructuring would not have cross-class cramp down, simply because there is only one class that you're dealing with, i.e. your scheduled lenders, whereas your pre-pack would have a cross-class cramp down inherently because you're going through IBC, which prescribes a cross-class cramp down. I think those are the differences that I can think of immediately.
So moving forward, we have a few questions from the participants. Um, the first one is that in the recent NCLAT decision in SBI versus Metiner, the tribunal reiterated the importance of an independent RP under the IBC. However, referring to the general scheme of the code, where the appointment and removal virtually vest directly with the COC, do you think that an RP can really be independent under the code? Also, does this raise the requirement of institutionalizing appointments of the RPs?
Would you like to begin or should I?
No, why don't you start?
So, see, firstly, let me give a caveat that my answer would be uh, uh, not very practice driven, because Pulkit is the person you should go and ask when he'll be the right person to answer. But I think this independence has been long debated under corporate laws. I mean, I remember independent appointment of independent directors, a lot of debate how to appoint independent directors. Now we have a new profession called IP, and there's a whole debate about who should appoint. Will he remain independent if one of the primary stakeholders appointing them? I think these debates have really lost its its merit over time for multiple reasons. See, firstly, one has to understand that mere appointment by a group of stakeholders in case of IP being the COC does not really sort of make IPs subject to any sort of lack of objectivity or biasness. And this is because one has to understand that mere appointment does not mean that person is not of integrity. If I recommend somebody's name and the person is of integrity, and as a committee of creditors we recommend a name in a person whom we have belief in, I mean, that does not really cast an aspersion on his integrity per se. Secondly, within IBC you have so many checks and balances. You go to the IBBI website, disciplinary committees have passed so many decisions against IPs who they've found they're not working in the interest of the corporate debtor, or not doing their job with complete, conviction ethics. The second check is the fact that, all these IPs get registered to one of the institutes. And be it ICAEW or ICSIPA, they also have this, systemic checks and balances on the IPs. And most importantly, IBC itself provides windows for all the stakeholders to, go and speak of any sort of malpractice that they find. So these are the few points that I wanted to put forward. And one has to understand that, the appointment of IP is important to be backed by COC, then institute, for multiple reasons. See, one has to understand that the IP needs to have confidence of COC, because IP is nothing. I mean, one of the judgments said there's most like IPs are more like a post offices, right? They're postmen. They don't take judgments on merits when a resolution plan is given to them. They rather sort of check on certain criteria and just pass it on to COC to make a final decision. Now, it is important that COC believes in this person who's an IP to ensure that the whole resolution process is smooth and it goes without hiccups. Institutional appointment, we have seen in the case of arbitration. I'm not sure. I don't have data to back up, but I'm sure that the ad hoc appointments by the parties, the decision reached, the challenge to those awards. I'm just saying from my experience, but nothing to be backed by data. But I think the challenge would be lesser in case there's a appointment of arbitrators by the parties then going to institution. The cost is lesser, so on and so forth. So I'm not trying to transplant the same sort of concept here, but IBC, because of it's unique in its own way. COC has so much of power. COC is believing in a person who is literally playing with, who's literally not playing, but sort of harnessing the company's its assets in the interest of all the stakeholders. There has to be a lot of belief and faith in this person. So I feel that appointment, is the right way that IBC allows appointment of IPs. I know, Pulkit, you would share some stories how IPs, there are a lot of backdoor, hands in gloves sort of exchanges that has happened. Those are bad experiences. It is left to law to really be guided by bad experiences. Should law, again, I reiterate, should law be premised because we had a bad experience, or should law be premised on good experiences and sort of create a better checks and balance for not to have bad experiences? That's what I firmly believe in. Yeah. Okay.
So this is, I think this is an excellent question. I really like this question, and it wouldn't be. I think it wouldn't be fair to say that there is no merit in institutionalization of IP appointments. Whereas I agree with Neeti wholeheartedly in everything she said, there is another side to it, unfortunately, or rather fortunately. So if you think about the Nordic countries and the Dutch countries, so I know, for example, in Germany and in the Netherlands, IPs are appointed from a roster. Only ever appointed from a roster, unless it's it's a voluntary liquidation, in which case obviously the directors appoint the IP. But where it's a contentious insolvency, an IP is appointed from a roster by the judge from his own or his or her discretion. It's not something that's left to the creditors to decide or for the debtors to decide. And there is a serious merit to it. I know this is not exactly institutionalization, but I think it perhaps achieves the same result, where a judge appoints an IP. If Karthikeya disagrees with that and wants me to stick to institutionalization, just drop a quick message and I'll do that. But I think it sort of achieves the same result. And so I'll carry on with the thought unless I'm interrupted. Now, the merit that's there in such a system is that the IP is not afraid of the banks. And there was a flurry of litigation, still is actually, in all of these countries, where the IPs take on the banks for having wrongfully granted loans, for having not assessed the viability of the company at the right time, for not having recalled the loans where there was a soft default. Now, you've got to understand the difference between a soft and a hard default. A soft default is where you have a covenant breach, and a hard default is where there is a payments default. So a lot of banks have covenants built into their loan agreements, facility agreements, where they say that your debt to equity ratio must remain this, your debt service ratio must remain above this, your current ratio must remain above that. So a breach of that, a ratio breach, would be a soft default. And it's just as bad as a cash default. And a bank is just as much empowered to recall the loan on a soft default as it is on a hard default. And so IPs would regularly bring claims against banks for not having done so. IPs would also bring claims against banks where there are preferential payments made to a certain bank. Now, that's not something that we see in India, unfortunately. It is something that we saw in the case of JP, but I think that that's an isolated incident, not the rule. It's an exception and not the rule. Whereas from the little experience that I've sort of amassed over the last couple of years practicing in the IBC courts, I have realized that in case of most companies, there will be something or the other against some or the other bank as a minimum that an IP could easily find and prosecute and try to bring that money back for distribution to the rest of the creditors. But they don't do that. And they don't do that because they are certainly aligned with the Committee of Creditors. In JP's case, they were able to do that as an exceptional case, for the reason that There, it was another company to whom money had been given. This bank was not a creditor as such to JIL. It was a creditor to JAL, which was the parent company of JIL. And therefore, the larger committee of creditors was in favor of this being done. So you're at a serious independence risk if you think about things like this. Otherwise, of course, you've got to have the committee of creditors' confidence. And being selected by the committee of creditors certainly has its merits, which Neeti has already explained. So I won't go into that. The other thing that really irked me when Justice Nariman said, respectfully irked me, when he said that IPs are just post boxes. I cannot disagree more with that. They are not post boxes. They are professionals. And if you just wanted a postman, well, you should have gotten a postman and not asked for chartered accountants who spent blood, sweat, and tears to become IPs. And practical situations lead you to believe that the truth couldn't be further from what he said. I've seen cases where there are suppliers who are pulling out. I'll give you an example of an engineering, procurement, and construction company. There's a company that I'm dealing with where I'm representing the IP. I have the pleasure of representing the IP before the courts. This is an EPC company, a very large one, where there is without getting into the specifics of the case, there is a road construction contract between India and another country, one of its neighboring countries, which was granted by the Ministry of External Affairs. And unfortunately, that contract has come to a grinding halt, and it's come to a grinding halt because there's no money. Now, who do you think is going to deal with the Ministry of External Affairs? Who do you think is going to deal with what's happening in that other country? Because obviously there are workers that are stuck in the other country. There are Indian workers who have migrated over to construct those roads. There are local workers, there are local contractors, and so on and so forth. And that, in addition to the pressure from the Ministry of Economic Affairs or any other ministry that may be involved, who's going to deal with that? The Committee of Creditors is not going to deal with that. You need somebody with some serious stone to deal with all of these stakeholders. And that's certainly not going to be a postman. And that's everything that I have to add to this. I hope I answered the question to some extent.
There is a follow-up with regards to your answer. So he has asked, I agree. Also, the case worsens where a single financial creditor has a debt share of more than 66%. What do you think?
Yes, certainly. I mean, comes back to say to I think I've answered this question by saying that where you've got IPs who are displaying partisan behavior, the minority stakeholders will be oppressed. There's certainly no doubt about it, which is why I said there is merit in the suggestion of institutionalization or appointment from a roster by a judge. But of course, there are counter merits as well. Now, the question is, what is the lesser evil? And I think everybody's got to decide for themselves what the lesser evil is. I think at this point in time, given that your creditors, after all, have to pay for the IP, right? Pay for the IP's fees. It's not coming from a central pot, after all. So the creditors have to deal with the IP, and they will only deal and cooperate with the IP if it's somebody that they trust. So there are counter merits. The question is, what's the lesser evil? Should we go to the next question?
Thank you, sir. So the next member of the audience has asked that the introduction of Section 10A and the exclusion of COVID-19 related debt from default opens up a floodgate for debtors to strategically default. Are we looking at a short-term solution and missing the bigger picture with the ordinance?
Pulkit, would you like to go first? Or?
You carry it.
I have a mixed opinion on that for multiple reasons. That at the onset, I must share that I don't agree with the blanket ban, blanket suspension of fresh filing of CRP cases. But you have to understand that probably in a country like India, where commercial wisdom is still much needed right now within all stakeholders, and also looking at the fact that courts are not functional right now. Uh, a lot of litigation would have started to prove or disprove whether the fault has happened because of COVID-19 or not. So the point on this is that multiple lawsuits have started, and probably it might have led to more floodgates of litigation where for petty defaults, people are running under different courses of law. Now, having said that, what irks me is that Section 10. I do not agree with suspension of Section 10 for the reason that I feel that a business person who's running a business is best informed about his situation. So I feel that the kind of taking away his right to continue or discontinue his business, it's something which I really do not agree with. And let me make a rhetoric that why I'm so very wary of law stepping into shoes for making decisions for business, be it appointment of IP as Pulkit. I mean, I was just answering the last question is, we have to understand that a man is most responsible when his money is put in the business, right? So for us, for people like outside that periphery, for courts, equity will be guiding, factor. For legislation, maybe public purpose will become a guiding factor. But for a person who's running a business, he has to look in his own right how much he can sustain the business or not sustain the business. So I personally do not agree with that suspension. But maybe, I mean, I'm sure legislation would have thought of a better. Intentions were definitely good. They would have thought something wiser for the country. Section 10, I feel that 10A, I think I'll leave it to Pulkit to look at the practical implications of that, of introduction of Section 10A. But I feel that as much as we feel that suspension would have really, sort of avoided multiple litigation, I think it might result in as a double whammy. For the reason that, I also agree that litigation would have probably flooded, especially as Pulkit said, so cheap in India. I'm now worried about what will be the fate once the suspension is lifted. What happens to that? And also, one has to understand that not every default that has occurred may be COVID related. So a blanket suspension does not really hold merit to that, because now see, we're already in an unlockdown period. We are sort of trying to ensure the business starts getting its momentum. There are few businesses like IT business, some technology business, which might have probably found more profit in this COVID time. So what are we actually looking at? So I feel that a better idea would have been probably what other countries have sort of done, like rather given the power and assurance to directors to make those bold decisions, take more risks, get into, to look for business rescue mechanisms outside IBC. And that could have happened probably very organically, understanding the fact that, anyways, going to IBC sort of gives a, sort of gives a moratorium on the assets, does not let them allowed to deal with the assets. So I think if you would have left it to the market and the business to decide, maybe a novel solution could have come out of it. But right now we have closed all the gates for that, and we're moving on the premise that businesses have to continue. So this is my limited submission to that. On the practical implication of 10A, I think Pulkit, you would be the best person to enlighten us on that.
10A is quite limited. In that it's limited to suspension of Section 7, 9, and 10. And of course, it relates to suspension of Section 7, 9, and 10 only in relation to defaults that have occurred during the prescribed period.
Post 25th March.
That's right. Now, during the prescribed period, and then, of course, there's the explanation which says that a default which has occurred during the prescribed period would never become subject matter of an insolvency petition ever. So that the perpetual bar the forever ban, essentially. That's how I'd like to call it. So the forever ban. So I think the only two aspects of it that I disagree with as such on principle is the ban, the suspension of Section 10, and the forever ban, and the forever ban actually per se. Suspension of Section 10 is still something that I would think that I could live with. But I think the forever ban just doesn't make any sense. And in fact, why even have a suspension of Section 10? It's voluntary on the corporate debtor, right? It's a voluntary remedy that's available to the corporate debtor to put itself into insolvency resolution. So why was there a need to suspend that? It's just something that beats me. And in terms of the forever ban, I couldn't agree with the inquirer more. It creates a serious risk of strategic default, because a person who otherwise, a company who would otherwise have defaulted later or could avoid a default would rather think to itself that let me default because there's a forever ban on initiating insolvency resolution in respect of my company if I default now rather than later. So why would I avoid a default if I, even if I can help it, I wouldn't help it. I'd rather say, all right, let's default now, and that's a serious risk. I think 10A is limited to that anyway.
And also, Pulkit, if you see, insolvency laws are designed and crafted for difficult times like these. Now, see, in America,
Yes.
JCPenney has filed Chapter 11 bankruptcy. Now,
yes,
of course, the jobs will be saved if some company comes and restructures and takes over. But, a complete ban, imagine a complete ban would not even allow JCPenney to explore those situations, right?
that's right.
In India, as such, you have very limited scopes and schemes for restructuring. I mean, the ones which are flexible are not popular. The ones which you have, are suspended. And so right now, I think we're struggling with windows to operate within. And a ban could just kill the options that you have. And one should not forget that, in India, you made a very conscious decision to put the business rescue mechanism within IBC.
Yes.
So why would you even suspend it? So,
Yes.
see, I might be sounding very theoretical, but that's what politicians do. I think a right way to IBC would have been probably have a business rescue mechanisms, introduction of new schemes and mechanisms along with the IBC, so that, if one is suspended, the other prevails. Pulkit, I'm told that there are multiple routes of restructuring in the UK.
Yes.
20 something.
Yeah, there's something like 20.
Yeah, 20 ways you could restructure. And here, the most celebrated law, which...
Yes, it's very, very complex. It's very, very complex. But again, that is a developed country, and we shouldn't we shouldn't try and try to achieve that.
Certainly, I'm not saying that. Yeah. My only limited point is that suspension have sort of closed even that window that would have allowed companies to restructure.
No, now, quite right. Yeah, at least the voluntary mechanism should have been left open, if not, as a minimum, I think.
Yeah. I see a lot of questions in the comment box, and I please moderators do ensure that all the viewers have been so patient. Their questions do get answered.
Sure, we do have a few more questions if that's fine, because we're running short of time. Yeah, so the next question is, while raising the threshold by 100-fold intended to secure corporate bodies from economic asphyxiation, might this cripple a smattering of companies, leading them to liquidation? What are your views on that?
How would a company go into liquidation? It's impossible. Simply because you can't go into liquidation straight away nowadays. You have to go through the CRP mechanism. Nobody has the power to put you into liquidation unless it's the ministry or on just and equitable grounds. And I can tell you from the little bit of experience that I have, JNE has never worked in India. Forget about India. In England, it's never worked. So,
in fact, JNE has worked the other way. It has definitely prohibited a lot of companies from going into liquidation.
Right. Yeah. So yeah, I disagree with that. Unless you can get into CIRP, you can't get into liquidation. That's just the statutory scheme in India nowadays. Unless, of course, you're talking about voluntary liquidation, in which case, which is perhaps not the case that the inquirer is asking about. I hope that answers the question.
Yes, thank you, sir. Another member of the audience has asked that the primary aim of the 24th March notification that raised the threshold was for the benefit of the MSMEs. However, isn't it self-destructive considering the fact that MSMEs do their business on a smaller scale, and therefore it would be reasonable to say that their claims are more likely to fall below the 1 crore threshold? What do you think?
I'll leave it, Pulkit, again. I'm sorry, I'm passing all the bucks to you. Audience, I'm just a teacher. Pulkit is the practitioner who's practicing law and seeing its implications in the courtrooms. I had spoken to a couple of IPs, Pulkit, after this was introduced, just to get, we run this GIP program, Graduate Insolvency Program. So just to sort of gauge as to how the market would be for us in future, for our students in future. I did speak to a few IPs, and there was a consensus among many IPs that it's a good, it's a good thing that default threshold has increased. And the rationale they shared was that, there was a lot of arm twisting happening under IBC. And they said that any default less than that, you have another mechanism, like if you are a secured creditor, you could go and enforce the securities, in a different fora. Why count IBC? So I'm not sure, Pulkit, if you could also share your views that was it really the case?
Yes, most certainly so, 100%. You see, before the IBC came in, people sort of knew that there isn't much that another person can do. Obviously, you could have filed a petition in the company court or the High Court saying that you're unable to pay your debt and therefore you should be put into winding up. But you see, that test was very different. That was a balance sheet test, i.e., it would be assessed as to whether you are unable to pay your debts, not whether or not you're not paying your debt. That was the ability, not the actual act of not paying. That was assessed in that case, which meant that a lot of companies who were otherwise solvent but decided not to pay a certain debt did escape those clutches. The IBC, on the other hand, changed the test from inability, i.e. a balance sheet test, to a default, which is a cash flow test. And I think the reason may have been more psychological than merited in law as such. Because if you look at most developed countries around the world that follow a common law system, most of them test a company's insolvency based on the balance sheet test, not on the cash flow test. England follows the inability to pay debts test. Singapore follows the inability test. Hong Kong does as well. So, there are a number of countries that do that. So I think it was more of a psychological reason as to why the test was changed, and that psychological reason may have been an attempt to change the credit culture in the country. So when you look at it from that lens, I think it's just fine what they've done. End of the day, legislation will follow political will, right? And where political will is to change the credit culture, you bring in something harsh like 1 lakh rupee limit threshold. Where the political will is to help companies survive, and you notice that, look, well, yes, it was being abused, but it was, achieving its eventual goal, which was changing the credit culture. But now we need a different culture altogether because we're facing a pandemic. let's increase the threshold. And I think it's achieving the target. I think it's doing the job. And I think this is not something that I would assess in an academic manner. This is more of a political question than an academic question, is what I would think.
If you could recollect, Dr. Sahu would always speak that IBC has brought a behavioral change in the market, and the idea was to bring that change that Pulkit just shared. And to Karthikeya, to your question that MSEs usually default below, so they do not get benefit, I doubt that. If you recollect, government has recently even changed the definition of MSMEs and SMEs. So I think now, is it 10 crores or something?
100 crores. It was 10 earlier, now it's 100.
10 earlier, 100 crores. So I think, so if a MSME is being, if there's a new definition in that light, I think 1 crore does suit them.
Should we go through the other questions?
Sure.
I know that there were a few more.
Sure. The next question is, what hindrances the pandemic would create in the implementation of resolution plans, which are already approved by the Adjudicating Authority?
Yeah, very good question. It has created a lot of hindrances, and I have a lot of clients who've turned around and said, look, at the moment, the question is of our own survival. Forget about trying to, restructure somebody else and revive somebody else. I think, this could raise a very, very interesting question. I don't know. I mean, I know that there was something being considered to give such companies an option to renegotiate or say that, all right, we're going to come out of it. The questions that are really raised are, one, well, what happens to the bank guarantees that resolution applicants have provided while their resolution plans were approved and then put before the NCLT? And two, if these bank guarantees are not going to be returned, right, by way of some statutory interference, what can we rely on in the Contract Act to get this money back? Because you've got to realize that, to restructure any company, a bank guarantee of, I think minimum bank guarantee that IPs have been asking for is something like 1 crore, which is going to be a lot of money in today's, in today's scenario. It may not have been so much, a few months ago, but in today's world, I think every penny really counts, and taking 1 crore away from any company is certainly going to, exacerbate their problems. So the question really is, then what do we look at? And I think the answer may well be in the Contracts Act, where 56 allows you, frustration. Of course, in your resolution plans, you may have incorporated something to do with force majeure. But in light of, the latest judgments that have come out of the High Court, Justice Pratibha Singh has passed a few judgments, handed down a few judgments in force majeure, where she's, averted to the fact that, look, force majeure will come to your rescue if you're trying to delay things, but if you're trying to get out of it, it's not going to come to you. It's not going to help you. You've got to rely on frustration. And I think that maybe an argument can be made that, look, I had come in as a resolution applicant thinking I would be able to resolve this company's insolvency. And I had represented that I was in a position to resolve the company's insolvency, having shown you my credentials. And I had represented that these are the issues that have led to the company's insolvency, and this is how I'm going to resolve these issues. But in today's situation, in today's scheme of things, I am no longer equipped to resolve this company's insolvency for the following reasons, which may be because of my own inherent deficit, or it may be that the market situation has changed, and the things that I had stipulated I would do to resolve the insolvency may no longer work, which could, one could argue, has resulted in frustration of this resolution plan, and therefore I should be given liberty to withdraw, or my plan should be rejected and my money returned to me. I come back to the lesser evil argument over here, And I think I'll just conclude that answer by saying that, look, what would be the lesser evil? Risking an otherwise relatively healthy company, I say relatively because it may have lost some of its health over the last few months, who was the resolution applicant, to try and resolve a company which we know is unhealthy, which we know is insolvent, or giving the best opportunity possible to the relatively healthy company resolution applicant to continue its survival, and liquidating the stressed insolvent company. I think the latter would be it.
Just to add what Pulkit said, I totally agree with Pulkit that the answer is not within IBC but in contract laws. In fact, I was sharing a panel with Justice Kumar Pulkit, and he talked about how courts now have to have a very pragmatic approach. And I said, I think that also entails that how court interprets these resolution plans who are just pending execution. They're already been, agreed upon. So of course there would be a MAC clause or force majeure clause. It's difficult to answer in certainty how they would act because it's very subjective test they'll have to apply to see what the contract entails. But I feel that one way could be probably have ex post negotiation between the parties. See, you have to understand that just because something has become commercially inviable does not lead to frustration. And the classic case to that, you all would remember the Suez Canal case. Court had, laid the law that just because it's commercially expensive to perform does not mean it is impossible to perform. So the test of frustration also would depend on how pragmatic the Indian courts are to sort of, give that kind of bold judgments. So another way could look at it is, could you defer the rights for certain time and then the obligations may arise later? And, Singapore, for instance, has deferred the rights of landlords to ask for rents and realize it later. So it does not exonerate the parties from the liability, but just defers it for a while till the market, gets normalcy. So I personally would believe that, frustration also should be very conservatively looked at, because the day the market regains, for all you know, that what they have agreed today for a lesser price may become very viable at a later time. So I think this should be left to the parties, maybe renegotiate what they have and agree to a lesser sum or defer those rights. That could be probably two possible ways to look at the resolution plans which are pending execution. Yeah. We have still many questions, right?
We'll just take two of them, ma'am.
Yeah. And, in case you still left with questions, Pulkit and I would be very happy to answer it over emails. So either you could ask the organizers or reach us directly on LinkedIn or emails, and we'll be very happy to answer your questions. Yeah.
Okay, thank you, ma'am. We'll forward your details to them. So Kartikeya seems really interested in insolvency. His next question is, the recent decision in the case of Maharashtra Seamless versus Padmanabhan Venkatesh, the Supreme Court of India upheld the Committee of Creditors' decision of accepting a bid from a resolution applicant which was lower than the liquidation value. Do you think this decision expands the scope of commercial wisdom to an extent which might backfire in the long run to lead to violation of the primary objective of the code itself?
Pulkit, I would request you to take this question.
No, I don't think so. I think it's perfectly fine. I think it makes perfect sense. You see, liquidation valuation is quite simply an academic exercise. It does not necessarily reflect, a fair market value, because that's only something that you can discover by practically putting the property to auction. I think to be married to an academic exercise that is conducted by somebody sitting in their offices would be a travesty. And to push a company into liquidation, which can be given to somebody, if you followed the process and that's the best option that's available to you, unless you can be really confident that, look, you will be able to get your liquidation value, I don't think it makes sense to reject a restructuring offer which is less than liquidation value. Especially when you think about it, there are other things that happen when you liquidate a company. It's not as simple as liquidation value is 10 rupees and you're going to get 10 rupees. No, that is not what happens in reality. What happens in reality, on the other hand, is that you reject a resolution plan, which is, let's say, for 8 rupees, right? Because your liquidation value is 10 rupees, and then you put the company into liquidation, right? You first pay your own CIRP cost, which otherwise would have been paid by the resolution applicant. So that takes away, let's say, 1 rupee. Then you're going to spend about a year trying to sell those assets, right? Which means that you've got an opportunity cost or an interest cost, which you've lost. Interest, let's say, is charged at the rate of 6% per annum, which is 6 paise in this case, right? So you've lost another half a rupee. That's 1.5 already gone. That gives you 8.5. Let's say you manage to sell the property for 10 rupees as you thought that you would. Fair enough. Now you've got to pay the liquidator's fees, which will itself come to about a few percentage points, which means that, let's say, you lose another rupee, which means that after a year of having rejected a resolution plan for 8 rupees, you've only gone and recovered 7.5 rupees, which would then be distributed amongst, any number of people. Somebody may go to court and say, actually, no, my rights are this, that, or the other. And you spend some more time litigating, and you take it up in appeal before the NCLAT, and you take it up in appeal before the Supreme Court. You all incur, your litigation costs, and eventually you will end up perhaps recovering like 6 rupees. So now what's happened? You rejected a plan worth 8 rupees to recover 6 rupees. I don't think that makes sense. You got to look at what's practical, not what's academic when you're dealing with insolvency situations. Yeah, that's everything I have to say.
All right, so the last question for today is, what will be the impact of the suspension of IBC on distressed M&A deals?
Neeti, do you want to?
See, I think it'll be very premature to say anything as to what would be the impact on M&A. For multiple reasons, that India has not seen many M&A deals in past few years because, but I feel that probably if there could be scope for huge, market for stressed companies, and if I see IBC suspended, but other windows like scheme is still there, or so probably if there could be restructuring, companies under stress could restructure using scheme, that could be. But of course, the efficiency of court will also have to be seen, how court could efficiently look into how the meetings are conducted, whether representation of all the stakeholders have been taken account or not. Those are practical challenges. But I think right now it would be very premature to say as to what how we look at M&A deals for multiple reasons. I mean, not just because we don't know the fate of scheme, but also look at how the economy is. Do you have enough liquidity in the market to really sort of boost M&A transactions? So I think I would not be the right person to really say that, because I don't know, a lot of macroeconomic concerns also comes into play when you talk about M&A. It's not just about the law. I mean, law is always there to support. We have window, but I'm not sure whether economic activities in India is strong enough to really support the kind of liquidity that is required for M&A. What is your view, Pulkit?
I completely agree with you. In fact, there are multiple laws that deal with M&A transactions, not just the IBC. You would have seen, I think it was just yesterday, that SEBI eased up their regulations on acquisition of distressed assets that are listed. And I mean, who's to say that that wouldn't boost M&A deals to cover up for whatever loss the IBC might have caused? I mean, I don't think that one can pick up one thing such as this and say that it's going to have an effect on a market which is a lot wider than IBC. M&A deals happen, as I said, under the, in respect of listed companies, stressed companies that are not insolvent raise money regularly, and what the SEBI has done, i.e., dispensing of the takeover code and requiring a public offer when you're acquiring over a certain percentage of a company, specifically in respect of stressed assets. That's certainly going to help. M&A deals and stressed assets also happen under the RBI circular, the June circular that we've talked about in a fair amount of detail. Specifically, if you look at, if you consider the case of strategic debt restructurings and all the other restructurings that related to SDR, which you can still do under the new circular, that specifically dealt with M&A deals in the stressed markets. And then, of course, you would have off-the-counter deals, or deals that relate to private companies that you'd never know of. A stressed company does not mean an insolvent company. A stressed company simply means the dictionary definition of stressed, which is a mismatch of its assets and liabilities. So I don't think I can say with any certainty that it would affect this thing negatively. Obviously, it does not affect it positively, but it may be that things are unchanged, or maybe that things are slightly negatively affected. I think that's how I'd like to leave that question.
Thank you so much, sir. I would request the rest of the participants to send their questions via email. So thank you, Mr. Pulkit Deora and Dr. Neeti Shikha, for such an insightful session and imparting knowledge into a variety of areas of IBC, like differential threshold, pre-pack insolvency, independent resolution professionals, the notification, and the commercial reserve. Thank you so much, sir. Thank you so much, ma'am.
In the end, I'd like to mention that, thanks to Priyanka, Dr. Priyanka, your faculty, who's also my student, the first batch of law I ever taught Pulkit. I started my career with Chanakya. 6 months I taught, then Priyanka was a student there. And she's the one who sort of connected us. And thank you so much. I must say,
ma'am. Thanks a lot.
Means a lot. I think quality of questions, Pulkit and I both felt are very good that you had. And it was a very engaging audience that we felt.
Yeah. Yes, no, I thoroughly enjoyed speaking to you all today, and you had some very, very interesting questions. I think a lot of them I'll go back and think about a little bit more as well. I apologize in case I wasn't able to address your questions to your satisfaction, but I'm ever so grateful for this opportunity to speak to you today, and I look forward to receiving more.
Thank you.
Sure, sir. Thank you so much.